Please make sure that you're still subscribed to the channel because YouTube keeps unsubscribing you guys, and I don't know why they're doing that.
Well, hello.
I thought we had a minute.
You don't have to file all the things every time.
I was ready for a minute.
You can file some of the things.
I was taking a minute.
You can file only the most relevant things.
We had a minute.
Remember that issue? Jurisdiction?
And it's been stolen from us.
I don't understand quite why he's filing this. Just wanted to make that clear.
What would KJ do if we all stopped talking about it? Like one day, just all stopped talking about it. Would a black hole open up in the earth? I want Cat Lawyer to be involved in this.
I'm here live. I'm not a cat.
Hey you guys, welcome back to my channel. Even after a Zoom hearing where both attorneys were told to stop bickering and be professionals.
Stop the social media things.
Katie Joy's attorney, Michael Brown, is at it again with a new filing that will probably annoy the judge, which in my opinion shows that Brown has some personal vendetta against Saltz and he's trying to use the courts to help him carry out his revenge.
Your Honor!
But before we start, do not forget to go down below and subscribe to the channel and ring that bell button so you can get notified every time I post. Also, as a quick disclaimer, I just want to remind you guys that everything we discuss here in the channel is my opinion and my opinion only, not to be taken as a fact. Always do additional research from the information that you get here in the channel. Do not send any hate to the people that I'm going to be talking about in this video.
Am I right, fellow adult?
However, I do encourage all of you to go in the comment section and let me know what you think about the situation. It looks like Michael Brown is after Michael Saltz in a huge and aggressive way that, in my opinion, is completely useless and could get Michael Saltz into very serious trouble.
This is about the attorneys slapping at each other.
So let's go over the motion for sanctions and the oral argument request filing.
We'll get to hear them yelling at each other.
On January 13, 2021, plaintiffs filed a declaration of non-party witness, Lori, on the quote-unquote second declaration, docket 38. That declaration was full of salacious testimony aimed at publicly accusing defendant KJ of perjury and accusing the undersigned counsel of very serious ethic violations, including attempting to procure false testimony from Miss Lori. By plaintiff's design, the second Lori declaration was almost immediately broadcasted to a massive social media audience.
As is the thing that you're also writing.
It's YouTubers suing YouTubers over YouTube shit. Of course we're going to cover it.
But Ms. Lori's testimony is demonstrably false in every material respect. Indeed, plaintiff's preparation, filing, and publication of it was defamation thinly cloaked as legal advocacy.
I'm curious as to the public promotion.
When they prepared and filed this declaration, plaintiff's counsel knew the quote-unquote testimony was directly contradicted by a long series of recent emails between Lori and the undersigned. But they proceeded undeterred and withheld from this court the very emails that proved the falsity of the testimony they had prepared. However, as far as I remember, there was a footnote in Lori's declaration that said that the emails would be available upon request of the court. Further, they knew the testimony they prepared was directly contradicted by a separate declaration she had helped prepare and was eager to sign on behalf of defendants just 1 week earlier, the quote first Lori declaration.
So?
He failed to note that she didn't sign the first declaration, which could make anybody assume that maybe the declaration is not true. Further still, they knew because Miss Lori told them that she was suffering from confusion, quote-unquote foggy thoughts, or memory and anxiety.
Swear.
Here's what drives me crazy. How would Brown know what Lori told Saltz? Plaintiff's counsel preparation and filing of false testimony clearly meets the quote-unquote bad faith standard and is sanctionable in itself. But the events leading to that preparation and filing are likewise abusive and improper and underscore the need for sanctions to punish and deter such conduct.
Oh, now we're just calling it false testimony.
The second Lori declaration came after plaintiffs' weeks-long effort to intimidate, threaten, and harass Miss Lori. On December 24, 2020, they filed a declaration that included totally irrelevant and extremely sensitive and damaging information about Miss Lori's past, which was by plaintiff's design broadcasted to a massive social media audience, causing Miss Lori embarrassment and anxiety.
Okay, so how did they exactly do that? How are you coming to the conclusion that that was their design?
What is this grand design?
On January 1st, 2021, plaintiff's counsel Michael Saltz sent private messages to Miss Lori, threatening that she could quote-unquote quote-unquote get in trouble for removing herself from social media in response to the public blowback from the December 24th filing, but offering to let her go if she agreed to cooperate with him privately and voluntarily. Here's the DM, and it says, otherwise we will be going to the courts to force her to testify and hand over documents. And if she deleted documents and evidence, she could get into trouble for that. We want to avoid all of that. Find out what she knows and let her go. Thank you in advance for being a good friend to Lori-Ann. It's obvious you care about her. It's obvious to me that this message was not a direct DM to Lori, and I don't think that the mentions of she could get in trouble and letting her go were any threats, in my opinion, but that's subjective. Let me know down in the comments what you think. On January 4th, 2021, Mr. Saltz filed a declaration in which he swore under oath that he personally conducted an investigation and determined that Lori had conspired with Miss KJ to quote-unquote hide evidence relevant to this lawsuit. These unfounded allegations also were amplified to a huge social media audience.
Lori-Ann lives in Washington, so it's relevant to jurisdiction.
And because Lori-Ann lives in Washington and there were alleged screen grabs of Lori-Ann saying that she lives in Washington in one of KJ's lives, those proofs have been deleted, and Lori-Ann has also deleted her Twitter. Therefore, the so-called investigation was on the memberships of the channels because it's relevant to jurisdiction to know where they are from, and that has been mentioned in one of his declarations. During the investigation, he determined that some of the chats between Lori and KJ were deleted, bringing him to the conclusion that there were efforts to hide connections between KJ and Lori-Ann because of the fact that Lori-Ann lives in Washington. Miss Lori finally relented to this assault on January 12 and contacted plaintiff's counsel in an attempt to make the harassment stop.
Really?
Based on the declaration that she actually signed, I don't remember that was the reason that she contacted the plaintiff's counsel.
She seemed to keep asking Brown, hey, have you contacted the other Lori-Ann? Have you told the other Lori-Ann? Have you told the court that it's the wrong Lori-Ann? I'm worried about the other Lori-Ann.
She told plaintiff's counsel she was represented by the undersigned in relation to this lawsuit. Nevertheless, they proceeded to interview her for 11 hours, reviewing her emails with the undersigned as well as her social media accounts, and then publish the results of their efforts.
What emails did they review? You don't know that for sure.
And on top of that, they also had a footnote that says, defendants deny such a relationship was formed. So not only he did not know exactly which emails Lori gave to Saltz for review, but he also denies representing her.
Okay.
This was a clear violation of what RPC 4.2 required them to do the moment she told them she was represented by the undersigned. This court should not tolerate this pattern of bad faith and abuse. Sanctions are warranted under, and this court inherit power to impose them. The amount of hearsay is ridiculous. How would Brown know what exactly Lori-Ann disclosed to Saltz? Based on her signed declaration, she said that he offered to represent her and file papers for her for free. And it was never clear that he was actually representing her. And then he puts a footnote saying that he never actually did.
Both lawyers in this case have gone just after each other.
This needs to stop. Didn't the judge just kind of tell them to stop?
I don't care who did what to who. Stop.
In November 2020, Mr. Saltz engaged in a Twitter spat with Lori in response to Mr. Saltz's many tweets about the case and about defendant KJ. Lori posted a tweet questioning whether Saltz really was plaintiff's attorney in this case. She asked because she did not believe quote-unquote real attorneys tried their cases on Twitter. Mr. Saltz responded by challenging Miss Lori to meet him in his office in person to discuss her tweet and threatening that he would sue over it.
I don't recall that.
Because that didn't happen. She just thought that he was impersonating an attorney.
I'm just going to ignore all this.
He also says that Saltz was threatening her with a lawsuit, and he also claims that it's not the first time that Saltz does that to people who are questioning his Twitter activity related to this case. Brown never attached an exhibit showing these alleged tweets. However, Captain Kate is an awesome friend friend and she helped me find the tweet. Here it is. Press pause, give it a read, and let me know if this sounds like a threat to you. On December 24, plaintiffs filed their opposition to defendant's motion to dismiss. They took that opportunity to harass Lori by revealing highly sensitive information about her. Information that has no relevance whatsoever to this lawsuit or to defendant's motion. They used the declaration of Kim as the vehicle for this harassment. The ostensible purpose of that declaration was to support plaintiffs' contention that defendant KJ knew she had a Washington subscriber to her YouTube channel, such that this court could exercise personal jurisdiction over her. However, the actual purpose is reviewed by the abusive but otherwise irrelevant content of the declaration. First and most egregiously, plaintiffs used the former declaration to expose an 8-year-old criminal charge that was brought against Miss Lori in an entirely unrelated matter. That charge was dismissed by the prosecutor, but plaintiff omitted that fact from the declaration. I'm sorry, I have to interrupt this here, but is Brown playing dumb?
Dumb ideas come from people who have dumb brains.
I am very worried for Katie because if he doesn't understand that that paperwork was put there to show jurisdiction, to show that Lorianne lives in Washington, it was not meant to make Lorianne look bad. This is just so stupid. Second, Kim included a detailed account of her side of an 8-month-old Twitter fight she had with Lori. Kim told only her side of the story.
Shenanigans.
Brown should know that that's how declarations work. You tell your side of the story. And included a tweet from Lori in which she stated that she knew people in quote-unquote biker gangs who would defend her if she were attacked. Kim did not mention the abusive tweets in which Lori was responding.
Much like defense, including a whole bunch of Twitter threads in a motion, including a tweet from me, but not showing what that tweet was in response to and saying it was in response to something else.
She quote-unquote testified with no credibility that because of that tweet in the 8-year-old criminal charge, she was quote-unquote afraid that Miss Lori and Miss KJ would physically harm her or her family. Honestly, I'm a little offended about this part because who the hell is Brown to dictate what kind of threats are appropriate for someone to be feeling afraid for their safety? This man is insane. Somebody come get this man. Finally, the declaration exposed the entire work email address and direct phone number of the person plaintiffs believed to be Lori. That by now we all know it wasn't, and also by now you should be aware of the fact that that's for jurisdiction, not to personally attack Lori. Neither the 8-year-old later dismissed criminal charge nor the Twitter exchange has anything to do with personal jurisdiction or this lawsuit.
It's been a little bit now since we discussed anything that's relevant to jurisdiction or this lawsuit.
This could have only been included to harass, intimidate, and punish Lori. Likewise, the inclusion of Lori's contact information, not even partially redacted, was unnecessary to the ostensible purpose of the Kim declaration. It could only have been done to expose Lori to unwanted public contact and to expose the inflammatory contents of the Kim declaration to her employer.
This stretching in this.
Honestly, it must be hell inside Brown's head because seriously, the conclusions that this man draws are crazy. In this next part of the page, he starts another conspiracy theory claiming that Emily D. Baker and Saltz are friends and it was a scheme to have Emily reading line by line in her YouTube channel this filing just to humiliate Lori.
Hi, I'm Emily Baker.
Why are we so desperate to make Emily an ally of Saltz?
And that is because Lori riled Saltz. Again, he accuses everything as a planned scheme from the YouTubes and Saltz to humiliate Lori, and saying that Lori lamented that the only thing she wanted to keep private was actually spread all over the internet. He quotes, "Thousands of people hate me. There are videos that will never go away and documents spread all over the entire internet that will never go away." He refers this quote from docket 52. I looked for it, I couldn't find it, so if you guys have it, let me know. But I am assuming that this one is one of the dockets that have been filed under seal. He also quotes, "I've had personal information shared about me, videos made betraying me, fearful for my kids and my grandkids' safety, my safety, had to deal with issues of incidents that happened 8 years ago." He moves on to start discussing the contacts that he had with Lori, 150 emails, 2 phone calls in 18 days. He claims that Lori made contact with the undersigned via email in December 24th, 2020. 2020, and that she explained that she understood that the undersigned was KJ's attorney and stated, quote, "I'm writing to you because the opposite counsel, Michael Saltz, have been harassing people, including me, on Twitter and has brought me up in the recent filing." She went on to explain, "I have done nothing illegal here, and this attorney, Mr. Saltz, took it upon himself to dox me in his latest filing, which has been viewed on YouTube by numerous people." That email began an extended conversation between Lori and the undersigned that was spanned 18 days and included some 150 emails and 2 phone calls. So this is the full email that he took only 2 quotes from, and this email is from December 24th. I thought it was important to put this email here because I feel like he's trying to paint a narrative that that's how she currently feels in February. This email is from December. We already have had a declaration from her signed where she is supporting Tati's side. So I don't know what he's trying to do here. In this next page, Brown mentions that friend of Lorianne posts a reply to Saltz on Twitter, pleading him to stop coming after her and claiming that her health has been declining since Kim's declaration. And according to Brown's reference, this is the tweet. "Lorianne used to be a loyal viewer. No longer. She did a super chat to say you were harassing her. She is not KJ's friend. That was a joke. Please leave this private person alone. You are causing harm to her health. Please, I beg you to leave her out of this." To me, there are several problems with this exhibit that, in my opinion, do not support the claim that this is to Saltz. We don't know who this lady is replying to. Also, there's a notion that Lori did a super chat to mention that somebody has been harassing her. Do you guys think that Saltz is going to be popping up at KJ's lives and be talking to the people in the chat? I don't think so. The last thing, in nowhere in this tweet, it says that Lorianne's health has been declining specifically because of Kim's declaration. Brown also claims that the same day Saltz found out about the compromise of Lori's health, he sent several direct messages via Twitter to Lori's friend. And that message we already know is the one that says that she could get into trouble, blah, 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 blah. I don't buy it. Brown mentions that 3 days after sending the DM, Saltz filed a declaration in the court swearing that he did not send any direct messages, let alone any messages that harass or threat Lori. And then the funny thing is, he says docket 30-1 paragraph 8. However, this was actually on page 6 paragraph 21, so we can see how skillful this Brown guy is. Here Brown goes and attacks again the fact that Saltz in his declaration make the mention of the investigation that we already spoke about earlier in the video, which is allegedly an investigation to find out that there was subscribers from Washington, which is relevant to the jurisdiction issue. But he also tries to make a way to vilify the situation and say that the grand scheme of things was to actually broadcast his findings to a big social media audience.
I feel like Brown has never done a case that has social media coverage, like not traditional media coverage, but social media coverage.
After YouTube videos started coming out with all of this information, she started getting angry and also despotent over being targeted for such brutal attacks that she had done nothing to deserve. And then he quotes an email that says, "Everyone believes what he, Saltz, is saying about me. Over 1 million people know all about me." I feel like Brown is taking that quote out of context, so I pulled the email out from his reference and we're gonna read together. But keep in mind that she also talks about the other Lori. So there's a lot going on in this email that he's not actually putting it into context here. It's very obvious that this behavior is legal. A successful, high-power attorney that wins all his cases knows the law. I will let him continue with it. Everyone believes what he is saying about me. Over 1 million people knows all about me. Now I have put others at risk all over this. Because of me, others are at risk too. They can show up at Lori's home or work, harass her and her family now too. All thanks to me. I'm done. He mentions another quote from Lori that says, "I've already been tried and convicted," from docket 52, which I assume is the docket that has been filed under seal. And in my personal opinion, because he has taken so many of these little quotes out of context, I don't believe that it's just that to this. He used this quote to say that Lori was convinced that she was going to be sued and thrown in jail.
This is fucking crazy.
Brown and Lori had discussed to make a declaration in response to the Kim's declaration that Saltz had filed. Also to address Saltz's threatening messages and his baseless accusations on his declaration, and the very limited nature of her relationship with KJ. She was, understandably, of two minds about this. On the one hand, she feared it could provoke even more the plaintiffs. On the other hand, she wanted to do something to defend herself and make it stop. Please correct me if I'm wrong, but as I remember, I think that she reached out to him not to make things stop. Obviously, I know she was annoyed, but I think that the main reason was because another Lori's information was in somebody's declaration and she was worried about that person's safety. He tries to support this claim by referring to his own declaration, as well as saying that she agreed to proceed with a quote-unquote first Lori declaration that he refers to docket 43, and let's pull that up. This is the email that he's referring to, and it's an email from him to Lori that says, "I'm waiting to hear back from the lawyer for the other Lori still. Would you be willing to file a statement that just says you are not that Lori and that your contact with KJ was limited to a few chats? You could also explain why you sent those tweets to Kim. It might be good to get your side of that story out there. Let me know if you can talk today." So according to his reference, that's it. It's just an email from him asking if she wants to do it. There's no Lori saying that she agrees to proceed with it. So I don't know what he's trying to do here. He mentions that that day she did on her own a lengthy statement describing her involvement or non-involvement in the lawsuit, her limited relationship with KJ, her Twitter experience with Saltz, and all of the stuff that she has experienced after the Kim declaration was filed. Brown drafted the declaration and sent it to her at 1:30 p.m. and then he says on the morning of January 6th. 1:30 p.m. is not morning, but whatever. He told her to review it and he said he would make any changes that she deemed necessary. Brown also says that after several back and forth emails, they found the final version. However, she did not have a scanner at home. He claims that she offered several alternatives between going to a friend's store or electronic signatures. That evening, he said to her that it was best not to file the declaration right away, and she agreed to it, allegedly.
We saw Lorianne apparently ready to sign.
That was the night that they didn't file it. And then KJ went live and was like, I don't even know her. They're trying to say she's my best friend.
Lori's irrelevant. She's not my friend. I don't know anything about Lori. She's not my best friend. I don't have a relationship with Lori.
Brown then starts to say that in January 7, the focus of the emails between him and Lori started to shifting to the topic of plaintiff's efforts to subpoena her emails and social media records. He again refers to docket 52, which is inaccessible, and then he goes on to say she was very worried that, as Mr. Saltz has explicitly threatened, she would get in trouble for having removed information about herself from social media. She was convinced that Mr. Saltz's conduct towards her won't stop, and she became convinced that what he was doing to her must be legal because he is a successful, high-powered attorney that wins all his cases. Decided to put the email back up because, again, I think he's taking this out of context here. The way I read this email, she's saying that she feels like that what he put on Kim's declaration is legal because he knows what to put on these kind of filings. By no means I'm saying he's right just because he's a lawyer, but I don't think that she meant that he's coming after her and he won't stop because he's a lawyer and he's successful, like Brown's trying to paint that narrative here. He claims that Lori became convinced that she was going to be added as a defendant to the lawsuit because of the biker game tweet. He quotes, "They have used me to be the violent one since I lashed out and said those comments." He claims that emails started getting a little more confused, and then he directs us to docket 52, which we don't have access. She even was worried about going to jail over it, but she claims to be better go to jail than to go through what she's going through currently. Lori called the plaintiff's counsel on January 12, 2021. By plaintiff's counsel's own admission, when she called them, she explained that she believed she was represented by the undersigned in connection with this lawsuit. He calls as a reference his own declaration, where he mentions in that declaration that he was on a call with Saltz and another attorney. And from his declarations, he says that during that call, plaintiff's counsel confirmed that Ms. Lori had told them she had called them on January 12, 2021, that she was represented by Brown in relation to this lawsuit. They also confirmed that she had given them access to her social media accounts and emails, and that they had reviewed those emails.
If Lorianne's not represented, which Brown says repeatedly, I never represented Lorianne. So you can't have it both ways, Brown. Pick a side, man.
After their 11-hour interview with a person they understood to be represented by opposing counsel,
But they weren't represented. You said that repeatedly. They weren't represented.
plaintiff's counsel hurriedly prepared and procured Miss Laurie's signature to the second declaration. Remarkably, they later explained that Miss Laurie told them she was often confused, had foggy thinking, and poor memory, was taking medication for a mental health issue that interfered with her memory and thinking, and was experiencing a great deal of anxiety, which exacerbated her symptoms. And then he repeats himself. I'm just going to skip that. The second Laurie declaration directly contradicts the first Laurie declaration.
But didn't sign.
Having secured what he wanted from Miss Laurie, that evening Mr. Saltz took to Twitter to thank Miss Laurie and call her the same woman he had 8 days earlier publicly accused of conspiring to hide evidence, a class act. In this next page is the arguments of the standards governing their sanctions and the inherent power of the court. However,
Not if the court doesn't have jurisdiction, they don't have inherent power. But this is saying that the court can punish people for adding shit to the proceedings, multiplying the proceedings.
If you have someone who's just inflating costs, they can be ordered to pay.
The court has power over the people in the proceeding once the court has jurisdiction. There's no power because we're still at the you're not the boss of me phase of this case.
is this happening because somebody's running out of money?
I'm not going to pay anyone $5 million. I'm not going to lose anything. Please remember that nothing you are hearing right now is fact or proven. I'm not going to go broke. I'm not going to file for bankruptcy.
Well, that's not what it's looking like so far, but let's see what else is in this filing. Plaintiffs decided to publicly expose extremely sensitive and highly embarrassing information regarding Miss Laurie.
As opposed to what Brown did? Are you kidding me? Brown is much more guilty of this than Saltz.
Without any legitimate need to support their personal jurisdiction argument. I beg to differ about that one. I do not agree. When they used Laurie's information, it was to prove jurisdiction, which is relevant to the case. And if they want to argue about the criminal record, it's probably because Kim wanted to show why she is actually concerned and she needed to air out her declaration. And also to show how KJ's supporters can be a little vicious. Don't we remember about the hacking event that happened recently? Brown also argues that Laurie and Kim's Twitter exchanges have nothing to do with personal jurisdiction or with the merits of this lawsuit. He also mentions that Laurie's criminal record is irrelevant to the dispute and does not establish personal jurisdiction over the defendants. He also says that the fact that Laurie works in Washington may help prove that she resides in Washington, but there was no need to leave her full email and telephone contact information to establish that fact. Brown claims that Saltz acted for oppressive reasons and improper purpose when he told Laurie that she could be in trouble for removing her own information from social media, but he could help avoid all of that and he would let her go if she could cooperate and speak with him privately and voluntarily. Brown mentions as a reference another court filing where sanctions were granted for behavior that he judges similar to what Saltz has done. Brown also tries to claim that Saltz's investigation was designed to try to humiliate Laurie by bringing all of her past into broadcasting in social media. Because according to Brown, Saltz just wanted to make Laurie suffer even more since he was aware of her mental state. I mean, that sounds so stupid. What Saltz has to gain from that? Brown argues that the plaintiff's counsel should be sanctioned for interviewing Laurie and reviewing her emails after she told them she was represented by Brown. He puts the reference of the law there, saying that in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer, or authorized by law or a court order. That also applies even if the person represented by a lawyer initiates or consents the communication. Therefore, if Laurie revealed that she was being represented by Brown, Saltz should have stopped any communication and not done an interview, much less filed a declaration for her. Brown claims that even though Saltz allegedly knew about this, he actually did no effort to contact Brown and instead proceeded to interview her for 11 hours, review all of her 150 emails with the undersigned, and obtain from her full access to her social media accounts, prepare a declaration that contradicts what they had just reviewed, secured her sworn oath to it, filed it, promote its broadcast to a massive social media audience. Defendants disagree that undersigned acted as Laurie's attorney.
Okay, but you say she wasn't represented by counsel.
You can't have it both ways.
But plaintiff's counsel's intent to violate this important rule in aggravated and dramatic fashion will remain whatever the court decides on that issue.
If I'm Salt, I can drive a fucking truck through this.
He goes back to talk about social media and how the design of this whole thing is to make Salts famous. I'm over this shit. I'm not gonna entertain this anymore. Let's move on. Finally, they discussed the meeting confer that they had, and Brown asked Salts why, even though he was aware of the fact that Lori gets confused and she suffers from foggy thinking, why would he still collect her declaration and go ahead and file it? Allegedly, the answer was that she seemed clear-headed when she was on the phone talking to them and telling them her accounts. Brown claims that they rushed to get her signature before she takes medication and she is impaired. Brown argues that this is an example of recklessness and bad faith from the plaintiff's counsel.
I wonder if that's really a fair characterization of the conversation. There's been enough animosity here to raise skepticism.
And another thing that I noticed is that it seems like Brown keeps saying that his declaration is the good one, but Salt's is not the good one. So why is her mental state not good for Salt's, but good for Brown? And then we have Brown's declaration with it's mostly him reiterating everything that we just read, plus his pricing menu to show that his prices are reasonable, since he's asking for relief on his hourly rates for the Lori declaration response and for the sanctions filing. Therefore, I decided not to go over that filing right now, but I'm gonna take a second read, and if there's anything I would like to discuss with you guys about it, I will post another video on it. Or if you guys want me to do a live on just that filing, let me know and we make it happen. Here are some things I understand from this filing. Brown wants to get Salts in trouble with the bar for improper conduct. Since he couldn't convince Lori to do it, he's doing it himself. He's also trying to get Tati's side to pay for the costs of him responding to the Lorian declaration and for this one sanctions filing. Because allegedly, Lorian's declaration and the fact that she lives in Washington could give the court in Washington that jurisdiction necessary to keep on going with the lawsuit in Washington. Therefore, they're trying to discredit Lorian as much as possible, so her declaration gets tossed, and potentially the judge decides that there is no jurisdiction in Washington for this lawsuit. But it doesn't matter, because in the end of the day, I'm pretty sure that Tati has enough money to refile it somewhere else. And ultimately, in my opinion, KJ is going to lose this.
More shit has happened.
When I thought I was ready to post the video, a new file came up, and it's the defendant's motion to shorten time on motion for Rule 11 sanctions. So they want to get that money quick, girl. It's a pretty short filing, it's just 3 pages, so let's do it. Defendants respectfully request that the court enter an order shortening time on their motion for Rule 11 sanctions against plaintiffs and their counsel. I did a quick Google search on Rule 11, and it's intended to make sure that when an attorney or a party submits a legal document to the court in a civil litigation, he believes in good faith that the document is truthful, supported by the law, and it's being submitted for an appropriate purpose. Basically, that's what Brown is accusing Salts of not doing. This motion will be based on the same conduct that forms the basis for defendant's motion for sanctions pursuant in the court inherent power. Rule 11 provides that a motion or sanctions brought thereunder generally must not be filed or be presented to the court if the challenged paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service or within another time the court sets. Emphasis added. If I was gonna guess what emphasis added mean, I would say that Brown trying to ask the judge to not wait the 21 days and get the ruling right away. However, the rule contemplates situations in which it may be difficult or impossible to comply with 21-day provision. And then he puts as an example another case that probably was not able to wait 21 days. And I guess I was right with my first guess here. Defendants submit that this may be the situation here. Currently pending before the court is defendant's motion to dismiss, docket 17. The focus of that motion is defendant's challenge to the assertion of personal jurisdiction over them. Defendants reside in Minnesota. Should the court grant defendant's motion and dismiss this lawsuit with prejudice on personal jurisdiction grounds before the expiration of the 21-day safe harbor, this court will lose jurisdiction to consider defendant's Rule 11 motion. Wow, Brown is playing heavy.
Brown is big mad.
As per my understanding, he is asking the judge to dismiss the case with prejudice prejudice. And I know that prejudice means that the judge does not believe that the case would be with merit anywhere else, so Tati wouldn't be able to refile the case in another state. Defendants submit that this result would be inequitable in that it would insulate plaintiffs and their counsel from responsibility for what defendants believe are clear demonstrable violation of Rule 11. They respectfully request that the court shorten the 21-day awaiting period to 8 days from the date of this filing.
It escalated in a way that I honestly did not see coming.
That is February 23, 2021. Defendants have sent their draft motion for Rule 11 sanctions to all plaintiffs' counsel via email on the date of the filing, and will also serve it by mail on February 16, 2021. The parties conferred regarding this motion to shorten time and regarding the Rule 11 motion on January 27, 2021. Wow, this filing was a huge twist for me. 8 days. What do you guys think is going to happen? Let me know down below in the comments. What do you think? And if you like this video, please don't forget to drop a like. Go ahead and subscribe to the channel now and ring the bell button so you can get notified every time I post. Also follow me on my socials. They will be down in the description below. I would also like to take a moment to give a huge thanks to all of the new members in the channel. And if you haven't done so yet and would like to get some neat member perks, go ahead and press the join button. Thank you so much for watching. I'll see you in the next upload.
Bye.